Let's be honest, when couples divorce, one of the first questions is, who gets the house? And if the house is only in your name, you might think that means it's automatically yours. But here's the truth in Florida, that's not always the case. And the biggest mistake people make is assuming the name on the title decides ownership. It doesn't. I'm Sara, a family law attorney here in Florida, and I'm going to explain why a house in one name can still be considered marital property and what you can do to protect your interest. In Florida, divorce isn't about who worked harder or who paid for what. It's about equitable distribution. That means the court divides marital assets fairly based on facts, not feelings. Now, let's break it down. Scenario 1. You bought the house before the marriage. It's in your name, and it's been in your name for years. You're thinking, this is mine, right? Not so fast. If you used marital funds to pay the mortgage, renovate, or even cover the taxes, your spouse might be entitled to part of the increase in value. That's called marital enhancement. I've seen clients shocked to learn that paying down the mortgage with joint money can turn part of that home into a marital asset, even if the deed never changed. Scenario 2. You bought the home during the marriage, but it's titled only in your name. Here's where people get blindsided. In Florida, if a property was purchased during the marriage, it's presumed marital. It doesn't matter whose name is on the deed. It matters where the money came from. Unless you can prove it was paid for with non-marital funds, like inheritance or premarital savings, it's likely going to be divided. Scenario 3. You own the home before the marriage, but later added your spouse's name. That's a big one. When you transfer title into both names, Florida law presumes it's a gift to the marriage. Once that happens, it's no longer just yours. It becomes marital property unless you can clearly prove otherwise. And here's something new. As of 2024, any gift of real property between spouses must be in writing. If you ever plan to transfer ownership, document everything. It's not just a technicality. It could decide who walks away with the home. I've seen this play out too many times. Someone comes into my office saying, "It's my house. I bought it before the wedding," only to realize they unknowingly turned part of it into a marital asset over the years. It's heartbreaking when something you worked so hard for ends up on the negotiation table because of details you didn't even know mattered. So here's the bottom line. The name on the title is just the beginning of the story, not the end. If you're thinking about divorce or trying to protect your property, get clarity before you make assumptions. And I want to hear from you. Do you think it's fair for a house in one name to be considered marital? Drop your thoughts in the comments. If you found this helpful, check out my next video on how to protect your separate property before and during marriage.